matter of owner-operator independent drivers versus New York State Department of Transportation.
Yes, I'd like to reserve 2 minutes for rebuttal.
Yes, sir.
May it please the Court. Charles Stinson for the plaintiffs' appellants, who are the Owner-Operator Independent Drivers Association and 3 independent trucker members. This case requires the Court to confirm a seemingly straightforward proposition that the state constitution applies to and limits state regulations. Specifically here, that Article 1, Section 12 limits the government's use of electronic logging devices and GPS tracking.
So prior to the electronic monitoring,
Yes.
or tracking, there was logbooks that were required, correct?
That's correct.
And that was permissible. What's wrong with tracking or documenting the time here?
Well, ELDs affect a more invasive search than did the logbooks. Logbooks were required drivers to record their duty status and general location, city and state generally, at change of duty status.
But the ELD doesn't give specific pinpointed location.
Well, I suppose that depends on how you define pinpoint, but it's more specific than a logbook was. Furthermore, ELDs require ping the location every hour in between every change of duty status as well.
But not continuous, which would be more invasive.
I suppose, yes. It could be more invasive. In fact, the federal government earlier this year issued a notice suggesting that perhaps it would like to record even more location information every 15 minutes in between duty
With
status.
a highly regulated industry,
Yes, Your Honor.
should your clients expect this to happen?
I think it's important to note that participation in a highly pervasively regulated industry, if we accept that trucking is, you don't check
Do you dispute that it is?
Not in this case, no. Not
Okay.
here. You don't check your constitutional rights at the door. The state can't condition your participation in earning an employment in waiving your constitutional rights. So yes, participation in a pervasively regulated industry does perhaps decrease your expectation of privacy, but it doesn't wipe it away. That's why the administrative search exception rule, the guidelines laid out by this court and KETA and other courts, that's why they exist, because you still do have an expectation of privacy.
So you argue that there's not a sufficient, I'm not sure these are your words, but let's just put it this way. There's not a sufficient nexus between the governmental interest and the problem they're trying to address
Yes.
and the additional information, so let's forget about the logbooks for a moment, the additional information to be gathered through the GPS. Could you address that more
Sure.
specifically? Because I wasn't really persuaded, but I may be missing something
Okay.
in your argument.
Well, I think that maybe wasn't my words, but maybe that should have been my words, because I think you put it very well there. So before with with logbooks, there was at least a stated need for location information in order to back up the information the driver put in the logbook, right? So if the driver picked up a load in Atlanta and got stopped in Albany, but only put that the driver had been going 6 hours, then there might be an issue there. The officer could double check that. But ELDs obviate the need for that information because they record when the truck is moving. So this location information is no longer needed. The hours of service, the calculation, it's found in 49 CFR 395.3, and that's been incorporated into the state law. Those depend on what the driver's doing and for how long the driver's been doing it. And ELDs record automatically how long the truck has been moving or not.
This is a bit of a logical problem for me, because I think you just conceded, and I believe you also conceded in your briefs, that the information that's collected by the ELD, i.e. location information, is part of what needed to be provided when they were just doing written logs, correct?
I think the state had a good argument that information was useful in backing up what's recorded on the state.
But factually, they had to log in some location information when they were filling out their forms on paper.
They did have to.
So is your argument, since I think we now all agree that location information is a necessary element, or has been prior to the advent of ELDs. Is your argument simply that they're collecting too much location information now?
And I'd like to hit a couple topics there. I'm not sure that we agree that location information is necessary to calculate hours of service.
I'm just saying, it was an element of what was provided even before the
Was-
ELDs.
That is correct. This case isn't about whether or not that was permissible.
No, you're not litigating that.
Yes. So I just say that to point out that we're not necessarily conceding that that was permissible, but it made more sense logically then because the logbooks don't automatically record when the truck is moving. So here, I think there's two points for why the ELDs are worse than the logbooks. And one is that point, that by recording automatically when the truck is moving, you don't need that location information to back up what the truck was doing.
But doesn't that get to the very heart? Because the problem, as perceived by those who created the regulations and required the ELDs, was that there was too much potential for falsifying the logbook information. And this sort of forecloses that possibility. Whether you think they're going about doing it the right way or the wrong way, would you agree with that general proposition that this keeps people more honest?
Well, that's one of the problems, first of all, and pressure from carriers on truckers was another big issue with logbooks. But I think there's a distinction, we need to make a distinction between ELDs generally, recording automatically this information, and the location information in ELDs. And whether or not there's a good reason for an automatic recording of hours of service is different than whether or not we need the location part of it. Because ELDs are recording when that truck is moving, so they no longer need this location
So are you
information.
saying that a trucker does not have to reveal whether it's through this tracking, put that to the side, never has to disclose location even to the carrier? Right now, doesn't a carrier need to know my truck is in wherever, Albany, whatever you said before?
Yeah, perhaps.
So that is not, because I think in part, the presumption you're working off is that the location is confidential, nobody gets that information.
Well,
It strikes me that that can't be right.
No.
But if it's true, it's true.
No, I don't think that's right. I mean, we're talking about I see my time's expired, but
Please.
We're talking about the government's invading truckers' privacy. I think there's a difference clearly between a carrier asking where its property is versus the government requiring drivers to turn over where they've been.
Yeah, but I'm sorry, but doesn't the carrier need that information to ensure that indeed the driver is either on duty or off duty? I mean, if you're in a location that has nothing to do with the duty assignment, that is revealing something to the carrier that is of consequence to the government.
I'm not sure.
Or have I misunderstood the way this works? That could be also.
I'm not sure. The government has not said how that would work.
I see.
The government has
When
never
you're
said.
off-duty, though, isn't the location tracked to a 10-mile radius, which is as big as all of New York City?
Right.
So what's the imposition of privacy there with that kind of radius?
Well, I think there's a balance. If the government hasn't stated why it needs that information, then any imposition on the location there is an invasion of privacy beyond Article 1, Section 12.
Counsel, I know your light is on with the Chief Judge's permission. Can you just explain for me a more practical issue? So let's say we rule the way you're asking us to on the state constitutional ground, and you are a New York trucker. You live in New York, you have this truck, you're working, you cross over the George Washington Bridge, you're in New Jersey, and the New Jersey safety officers pull you over. Do you have to provide this information to them?
Likely, yes.
So what would the practical effect of that ruling be? It would only be that New York safety inspectors couldn't ask for the information, right?
That's true. And I think, first of all, the state constitution applies either way, right? I mean, the state constitution is there to protect individual privacy. So any private information that you don't have to give up to the government, I think, is a win.
True, but since you're asking us to do this on a state constitutional basis, one of the issues we look at in the analysis, not a dispositive one though, is uniformity, right? So uniformity is a factor, not a determining factor. And where you have 48 other states requiring this information now, shouldn't that be a fairly weighty factor here? Where the only limitation then at the end of the day would be New York safety inspectors can't pull your truck over on this side of the George Washington Bridge.
I don't think so. I think that, as I said, the regulations, they always tend towards digging into truckers' lives more and more. So anytime the truckers can get a win on that side is a win. So protecting their privacy.
Win would only be producing it, not having to record it, right? For practical purposes, you'd still have to record this information. The only win would be you wouldn't have to give it up to New York officials.
Perhaps, but I think we consider that to be a big win.
Thank you.
Thank you.
Counsel?
All right, good afternoon. May it please the court. Kevin Hu on behalf of the Department of Transportation. The ELD rule is constitutional because it authorizes only limited administrative searches that easily meets all the elements of the pervasively
So why do you need the location data?
That's a fair question, Your Honor. So it's important to emphasize that under the hours of service regulation, truck drivers are allowed to use their commercial vehicles for personal errands. And so really the only way to distinguish when that duty status, the authorized personal use, is being properly used is to record some degree of data that can help distinguish when a personal task was being accomplished versus when time is actually being used to perform work functions.
But there, aren't you really relying on their say-so?
That's correct, Your Honor. So the duty statuses do have to be manually entered by the driver. And so when a driver selects authorized personal use, there certainly is a presumption that they are doing some sort of personal errand.
And so how does the location information then tell you if they're not telling the truth in that circumstance?
So the location data, first of all, it's an objective, easily understood set of data. And so to use an example, if a truck driver has a job that takes him from New York City to Los Angeles, and the records show that there were multiple personal errand designations throughout that trip, and also the location data shows that those personal errands continue to take him in a westward direction, that would certainly raise a red flag that there was a potential that the personal errand duty status was being used in a potentially improper way.
Is it actually used that way when someone is pulled over, or is that just a hypothetical possible way in which you might use the data?
So, Your Honor, the data is typically reviewed in two ways. First, the department does randomized stops, and in those stops, the driver has to furnish 1 week's worth of data. And so to the extent that there are red flags visible in that 1 week's set of data, they would follow up with a further inquiry.
And you're saying that that is in fact what happens, not just that it can happen?
That is right, Your Honor. And the second way that it is used is the department conducts audits with the motor carriers themselves. Drivers upload their data to the motor carrier employers, who then keep it in 6-month batches. And so the department will then look for patterns in the data. So for example, if a driver consistently completes trips here in Albany and then uses the personal errand duty status to complete round trips to New York City and then come back to Albany before going on duty again, perhaps he's just visiting grandma, but perhaps he's also, with that sort of regularity, completing some sort of work function that would, again, require follow-up. It's not necessarily the geographic...
I'm not sure how the location data would help you distinguish between those two things. I mean, he might visit his grandma weekly.
That's right, but the regularity and the pattern in that data would allow the department to follow up and just provide and just ask the questions. It's not necessarily the geographic data will reveal with a certainty that someone is committing the abuse, but it's a way of identifying red flags to ask
So
follow-up
are you
questions.
saying it allows for assistance with an audit?
That's right, Your Honor. And again, because duty statuses must be manually implemented, there still is that potential to manipulate the driving time. And the federal government did consider certain technology that would eliminate abuse of the duty statuses. But ironically, those technologies would be significantly more intrusive into the privacy of these truck drivers. For example, on body cameras, biometric scanners, those sorts of things.
Can I ask you what happens when law enforcement, how do they collect the data? Do they actually go inside the truck? Do they have to access anything inside the cabin? How does that work?
So when a truck is stopped and is asked for the data, the data transfer is actually completely electronic. And so the reviewing state agent is not allowed inside the vehicle. They cannot conduct a search of the vehicle the vehicle itself. The data is transferred through the cloud or email or through a USB. And then the reviewing agent then looks at it in his or her own
So
vehicle.
it's not reviewed there on site, it's reviewed later?
It could be either.
And then if they review it on site, what do they do? If they think there is a red flag, what do they do?
They would ask follow-up questions. Drivers are required to keep documentation for precisely this purpose.
And if they think there is a violation, what would they do?
There are violations of the hours of service requirements are subject to both civil and criminal
Yes.
penalties.
Yes.
But those don't get adjudicated on the side of the road, do they? I mean, there must be a process for that.
That's correct, Your Honor. The department, the DMV and the Department of Transportation would have the authority to then initiate a proceeding to,
So are they issued a ticket? I mean, I'm just trying to figure out what happens on site, if indeed the information is reviewed on site. Otherwise, I don't know why it's being reviewed on site.
I believe they would be issued a ticket, but I have not discussed that question with my client. But I will say, though, that when a truck goes through one of those checkpoints and has their data reviewed, they then receive a decal that they can stick on their car, so that if they get caught up in another randomized inspection, that decal actually allows them to be pulled out of the stop and just sent back on the road.
How long is that for?
Right.
Excuse
How
me?
long does that last, your
3 months.
pass?
3 months, Your
For
Honor.
3 months.
Yes.
Can I ask you technologically, I've been listening to all the seemingly valid areas of inquiry, administrative inquiry that can be done with the ELD information, but it seems to me that you could probably do much the same thing even if you just turned off the location finding feature of the ELD when the driver put in that they were on personal time, off-duty time. So technically, can you do that? Can you just instruct the ELD that when the driver puts in off-duty, that it just doesn't track location at all?
I don't believe the ELDs have that functionality, precisely to prevent situations where a driver might improperly try to withhold the location data. But it's worth noting that
But can't you, you gave this hypothetical about how the driver is consistently moving in a westward direction, and that raises a red flag, and I completely understand that. But if it wasn't tracking location during the off-duty time, you could still see the westward movement. The same red flags would go up, but you would deprive your adversary of the argument that you're monitoring location during off-duty time.
that's correct, Your Honor, but it's worth noting that the personal errands will not necessarily take a vehicle will not necessarily take a vehicle in a concrete direction in that manner. So going back to my example about someone who goes on and off duty in Albany, but then completes a round trip to New York City, a circumstance like that would not, if we were to only look at the location data when he switches duty status, it would not capture that round trip to New York City.
Do you have any information on how frequently the use of the location data along the lines of what you're laying out has actually yielded a finding that someone is breaking the hours of service rules?
Unfortunately, it's not in the record, Your Honor, given the facial challenge. The posture of this case is a facial challenge. We don't have specifics about how many hours of service violations or...
So you can't tell us if it's, for example, 1 out of 100 stops or 1 out of 100 truckers or something that would give us some sense of the efficacy of the access to the data?
I unfortunately do not, Your Honor, but perhaps it's worth noting that in the reply brief, my adversary cited a study that looked at the first 8 months after the ELD rule was adopted at the federal level, and even that study found significant reductions in hours of service violations because all of the relevant data entries are now automatic. So it's simply that much more difficult to falsify.
You mentioned audits of the carriers, which accesses the same data, right? But
That's
through the
right.
carrier. Is there a protocol or guidelines as to when those audits occur?
I'm not sure, Your Honor. The carriers are required to keep ELD data in 6-month batches compared to the 1 week that a single driver is required to. But the Department of Transportation is ultimately bound by federal guidance. So to the extent that there are any federal rules setting forth limitations on those audits, they would certainly apply.
So let's say that there's an investigation going on. Maybe it's undercover, maybe not. And that leads to a determination that there may be, because you concede that criminal penalties can apply to some of these violations, that the violations raise to the level of warranting criminal penalties. Does law enforcement go to the carrier and say, I want to see these many months so that I can pursue my investigation? At that point, do they have to get a warrant? Or is this hypothetical nonsensical? It doesn't work this way.
Your Honor, I don't believe the hypothetical works because the only way that they would be able to, perhaps your hypothetical might work in one situation, which is using the 1 week data, they
Yes.
find sufficient red flags that they then want to see the 6-month circumstance. In that scenario, because we are still, because the elements of the pervasively regulated industry exception are met, I do not believe law enforcement would need a warrant in that circumstance.
So the federal regulations, if I read them correctly, limit the use of the ELD data to enforcement of the hours limit.
That's right.
Is there a parallel legal restriction in New York?
We have
Bound
adopted,
to you adopted them?
that's right, that restriction has been incorporated into New York by the wholesale adoption of the federal regulations governing the ELD rule.
So you're bound by those?
That's right, Your Honor. Great, and unless there are any further questions, we respectfully request this court affirm. Thank you.
Just like to touch on a few topics here. First, with respect to that, your last question, Chief Judge. The federal regulations don't limit the scope of ELD data, the use of ELD data. The Appellate Division and the Department have cited the federal statute, which is an enabling statute that tells the Secretary of Transportation that it should limit the use of ELD data to enforcing hours of service, but that wasn't incorporated. And in fact, the Department, in its motion for a motion to dismiss, cited an affidavit from an officer in New York that said, we're only using ELD data to enforce hours of service rules. Well, that's not good enough with a warrantless administrative search. That needs to be in the face of the rule. It needs to be, give notice to people who are, this is a facial challenge. We're talking about the rules authorized, or excuse me, the search is authorized by the rule. A couple other notes.
Can you address his example about the trucker who goes between the city and Albany, and that might raise red flags? Can you address that? Why isn't he right that that's an example of how this is very useful?
Because it's not in the rule. Again, this is a warrantless administrative search. It needs to be in the rule that says exactly how that's going to happen. The Department cited to some mentions of location data in the federal rulemaking notices that basically just say we're going to use location data to do that, or we're going to send it to an algorithm to do that. But they don't ever tell how that's going to happen, and it's not in the rule. It's not adopted in the rule in New York. This is the point of a warrantless administrative search, is that the law authorizing these searches needs to be narrowly and precisely tailored. That's what this court said in Kita. In order to ensure that targets of the search know what's going to happen and that officer discretion is limited. This rule is deficient in those ways, in that it doesn't say how this locations data is going to be used. I'd also like to note that the study that my colleague referenced was not only mentioned on the reply, it was presented to the department at the rulemaking that says, yes, ELD use, and I see my time is out, I'd just like to finish.
Just
continue. Yes, ELD use may decrease hours of service violations, but the ultimate goal here is highway safety, and what is not accounted for is the unintended consequences of rigid hours of service enforcement in a vacuum that then causes other safety issues down the line, and in fact works against the ultimate goal of highway safety.
I'm sorry, if I may.
No, of course.
If you could just clarify that, I'm not really sure I understand. Isn't the presumption that if, excuse me, if there aren't violations of the amount
Hours
of
of service.
time,
Right.
the amount of time that a trucker's on the road, that would, common sense, that
Right.
would reduce any kinds of accidents, because you just don't have someone who's
Sure.
tired or perhaps falling asleep on basically what is a weapon of mass destruction.
Sure, and let me be clear, there's perhaps no group for whom highway safety is more important than truckers. They spend their lives and livelihood on the highway, and it is so this isn't about safety on one side, not safe on the other side. The problem is when you are faced with an ELD, and let's say you get stuck in traffic, and you're running out of time on your hours of service. The driver is often faced with the decision of, do I speed to get to my place in time? Do I violate the hours of service? Or do I pull over in an unsafe location and stop until I can drive again? And because of that kind of choice, the evidence out there is that ELDs don't make the highways more safe. And
So what do
this
they choose? I'm sorry, what are you saying they choose, and what, it sounds like you're saying the ELDs incentivize particular type of conduct. What would that be in that scenario?
Well, yeah, in that scenario, it might be that you have to pull over on an on-ramp that's not safe. So I think you're right in that, yes, maybe logically, and the presumption is that, yeah, this is going to reduce accidents, it's going to be good for everybody, and that's the position the federal government took when it adopted the ELD rule in 2015, made it mandatory in 2017. The department here had a few years of evidence to see whether that was actually the case, whether the ELD rule actually helped safety. And the Owner-Operator Independent Drivers Association put that evidence in front of them during the rulemaking. Thank you, Your Honor.
Thank you.